SkyTrain scandal. Yes, SkyTrain scandal. Professor Emiya Ekonfi, $2 million. Now, in some no copy court, I may just say one updates about just say any answer to Abuja, say your call, now your call equity. Now, a year gifting our remains are related to a year NSS, a year ghost name scandal. We are gifting our remains are updates and also high courts. Na ensem no abusua baby a ekeka kọ eni baby a abusua ensem no akwa kodru na dia pese me no mienu yekọ na yetie na yetumi ekire ya adwen yes titru efa eye SkyTrain scandal $2 million professor Moyewe Konfi na ene eye NSS eye ghost name scandal abusua sansem we yete ho nsem ache ayakoye se chema wuntumi ni case adubu ahim case ene eye Abdul Hanan, a former Buffer Stock CEO, just almost some, like just say, a social media so far. Nene, and some about Bonteno, a year Professor Amiwa Confiscate Trade Scandal, and a year gifting our remains son. Now, with your copium our court, gifting our remains son, it is alleged, said, almost a file BB, now started almost file, no, na high court, I hear Eddie Afan, Abusa, where the young court, na yinti, na yinti, and Chaya. That's why you bear media. That's why I say, and any day you connect your channel, it's a video console. But they also subscribe. Eddie, I'm a notification bell for podcast updates. Yentium command, just say about Monte, and Masses here. Yes.
In 2024, when Dr. Keso Atuforsen and Richard Japa and Dr. Sylvester Nimana, they were the accused persons in the ambulance purchase trial. It was on a similar tangent. They challenged the decision of the High Court, which asked them to open the defense, and they won. Now, when they won, they were acquitted and discharged. And then more recently, has to do with the case involving the National Service Authority Deputy Director, Gifty Oware Mensah. Mm-hmm. Her lawyers also filed challenging the court's decision to ask them to file their statements. But when they went to the Supreme Court, theirs was thrown out. And so these are the nuances around
anything could happen.
Indeed. We're seeing what will happen on the 24th when they go to court. And I need to put on notice that this motion, the injunction application which has been filed by lawyers of Solomon Asama, has been fixed for hearing on 27th August, which is on Thursday. So we're still waiting to see how things are pan out.
So there's still going to be Monday when they go for the CMC. But, in all of this, we have referred to Solomon Asama, but we know he's not the only accused person in this case. Now, while his actions may affect the other accused person, my question to you is whether or not we've heard from the counsel or from that party to the case.
Well, as far as this case goes, the lawyers for Professor Amir Kunfi tend to be in conference or tend to move along the same tangent with lawyers of Solomon Asama, although Solomon Asama has the one whose lawyers have penned their signature on the documentation. They tend to move in the same direction. And so, of course, they know that whatever the issues regarding this documentation is, it directly affects them. And so they are on the same tangent as lawyers of Solomon Asama.
Lord, great job on this case. Thank you very much for the reporting. Lord Eduasare is our legal affairs correspondent. This case is just as elusive a little bit, maybe, but it's just like the SkyTrain itself, the project itself. We'll move away from this. Interior Minister turns to police to deal with vigilantism. Let's get into that now. Now, a former chief executive officer of the Ghana Infrastructure Investment Fund, Solomon Asamoah, has asked the Supreme Court to halt proceedings in the criminal case concerning the controversial Accra SkyTrain project. Asamoah is seeking an interlocutory injunction restraining Justice Audrey Kokuvite from continuing to hear the case pending determination of his application for certiorari and prohibition. Solomon Asamoah and Professor Oware Application are both facing multiple charges, including dissipation of public funds, causing financial loss to the state, and stealing in relation to a $2 million SkyTrain project, which did not materialize. They have pleaded not guilty and are on bail. Lord Edwasare is our legal affairs correspondent who's been following the story from day one. Let's unpack all that we have heard, the legal jargons especially. Lord, good evening to you and thank you for staying up for us here on Ghana Tonight. But we hear that new applications are being filed. What exactly is this one meant to do?
Right, Kimnia. So this application, which has been filed by lawyers of Solomon Asamoah, the former GIF CEO, is an injunction application, basically. And from the face of the documents, they filed it today. The date on it is 21st August. And I'm just going to run you through the release. It's basically restraining the presiding judge in the matter, Justice Kokuvite, from proceeding to hear, continue with, or determine any parts of the case, which is against Solomon Asamoah and then Professor Oware Application, pending the hearing and determination of the application for the orders of certiorari and prohibition. Again, they're also asking for an order to suspend the operation and enforcement of the High Court's order, which was on 30th July, directing Solomon Asamoah to file his witness statements within 21 days. And so, Kemini, basically, when the High Court ordered Solomon Asamoah and Professor Oware Application to open their defense, they challenged that decision by the court, went for an appeal, and whilst that appeal was pending, they filed an application for the courts to halt the proceedings pending that appeal. The High Court judge threw that application to stay the proceedings out, and then they asked them to file their witness statements.
Right.
Now, following that...
No, so hang on, so we don't confuse our viewers. I want you to focus on what they're seeking now. We'll look at the timelines later. This interlocutory injunction, because it would appear that the case makes, it takes one step forward and multiple backwards. And so what they're seeking today is exactly what? To do what?
What they are seeking today is the injunction application to restrain the High Court judge from continuing the process or continuing the proceedings at the High Court. Now, they are saying that because they sent the case to the Supreme Court should injunct her from hearing their case pending that substantive suits which they have filed at the Court of Appeal.
So now let's look at the timelines and why those are crucial to the case or the application they have filed now, because there appears to be a situation where it is one injunction after the other, or excuse me, one application after the other, right? So let's start off from the 10th of June. Where are we at as of the 10th of June?
Right, so on the 10th of June, at the close of the prosecution's case, Solomon Asamoah filed a submission of no case to answer, arguing that the prosecution had failed to establish a prima facie which would require him to open his defense. 2nd July.
So by this time, the 10th of June, prosecution had rested their case. So then the judge says,
indeed,
defense, now open yours, correct?
Exactly.
Right. And then you say that is when, after prosecution giving their, detailing out their case, right?
Their case, essentially. Yeah.
Defense now says that prosecution has no case, and so throw it out.
Indeed.
But what does the judge do in this case?
So once the prosecution closes his case, submission of no case has been filed, High Court dismisses the submission of no case, it essentially means that the defense, in this case, Solomon Asamoah and Professor Amir Kunfi, are supposed to open the defense per the court's procedure or directive.
Right.
Once the prosecution closes this case, defense has to file a submission of no case if they are so minded, and then once the judge rules on the submission of no case, they'll be made to open the defense. And so that order was given on 2nd July. And then on 20th July, Asamoah filed an appeal against the ruling which ordered him to, as it were, open his defense, or the order which dismissed his submission of no case. They believe, or their case was that the prosecution had not proved enough for the court to say that they should open their defense. And then on 21st July, he then filed a stay of proceedings pending the appeal, or pending the challenge of the High Court's order which asked him to open his defense. A week afterwards, 30th July, the High Court dismissed that application to stay the proceedings at the High Court pending.
So hold on. Before we go to the 30th, between 20th and 21st, it would appear we see two different applications going on. Because on the 20th of July 2026, that is when Asamoah's counsel files a notice of interlocutory appeal against the ruling. The ruling being, Judge Kokuvite. Indeed, Judge Kokuvite saying that they have a case to answer, and so they should open their defense, right? So, and then 21st July 2026, they also filed a motion for stay of proceedings pending the appeal. What exactly happened between the 20th and 21st?
Well, mind you, when they filed their notice of interlocutory appeal, their case was that the prosecution had not made any substantive case, for which reason the judge asked them to open the defense. And so they escalated the matter to the Court of Appeal, right? And that's why they filed the notice of appeal. And then they were back on 21st July to file the motion to stay proceedings at the High Court. So what they're telling the High Court judge is that we are appealing the decision that you ordered us to open our defense. Now, while the Court of Appeal is yet to set a date to hear and determine the matter, the case at the High Court should be put on hold, because whichever decision that the Court of Appeal takes will have a great effect on the trial in the High Court. So that was what happened. That was what the document on 21st July was about. And then we got to 30th, where the High Court ruled in the application to stay the proceedings and dismissed it.
I see. So when it was dismissed, it meant that defense had to open their case. So let's talk about that. How much time did they have to open their case when the stay of proceedings application was dismissed?
So the judge ordered Solomon Asamoah to, within 21 days, file his witness statements, after which a case management conference, a date for case management conference was set. Now, what this simply means is that once they filed their witness statements, the prosecution and then the defense lawyers will go through the documents that they were relied on for the trial to begin. In the witness statements, Solomon Asamoah is supposed to indicate the number of witnesses that he will call on, or if he himself, he will testify on his own behalf. Now, all this was supposed to have been decided on 24th August, which effectively was this coming Monday, right? And then today, they filed an application at the Supreme Court invoking its supervisory jurisdiction for orders of certiorari and prohibition, challenging the High Court's ruling of the 2nd July and then 30th July. Now, mind you, the 2nd July was the order which asked them to open their defense. The 2nd July ruling had to do with them dismissing their submission of no case, and then the appeal, which is yet to be heard. So they indicated in their application that, which they had filed at the Supreme Court, that an injunction should be put in place pending these other applications that they had filed.
I see. And Lord, if my math is right, the 30th July directive that they should file witness statements in 21 days. It meant that expired on the 20th of August. Right. So, talk to me. Are we aware that any witness statements were filed then, because it had expired, and we look forward to the 24th of August, which is Monday? What happened on the 20th of August? No witness statements were filed?
Well, hard to conclude, but it appears so, because in between time, when the case was called and the lawyers came to court, the substantive lawyers themselves were absent. And then the presiding judge told the lieutenants or the junior lawyers who were present that they should tell the substantive lawyers to make sure that by the time they come at the next hearing, they would have filed their witness statements as directed. Otherwise, the case would proceed. And I clearly recall that the Deputy Attorney General, Dr. Justice Ramsay, who was upset about the development and was pleading with the court to proceed and then eventually give its judgment, because he indicated that the timelines or the period that had been given to the defense lawyers had elapsed and they hadn't gone ahead, or they hadn't obliged the court's directive. And so he was saying that if no documentation or statements have been filed, the court should go ahead and then make its judgments and convict them where they are found guilty. And then the judge indicated that he's going to give them one more chance for the substantive lawyers to come to court to come and do what is right. And so on Monday, it's going to be interesting. We're going to find out if they are going to tell the court that they have filed it, but then in as much as they have filed it, there's also the matter which they are put before the Supreme Court.
August 21st to deliver its ruling on the... Now, the Supreme Court has set Friday, August 21st, to deliver its ruling on the injunction application seeking to restrain the specialized court sitting during the legal vacation of Hwasia Yerebi MP Kojo Nkrumah filed a writ at the Supreme Court challenging the decision by the Chief Justice to allow some judges to sit and hear criminal matters during the legal vacation. He's praying the Apex Court to declare the warrants issued by the Chief Justice as unconstitutional. Oware was in court. He's joining us with a bit more from there. Lord, what else can you tell us about this latest development?
Today, to start off, Gibos Kopaman as the sole judge presiding on the matter. And once the case was called, the lawyer representing the MP for Hwasia Yerebi, led by Frank Davis, he argued that, for example, the Deputy Attorney General, or essentially the Attorney General, should not be representing the Chief Justice as a legal counsel in the matter, since the Chief Justice is a respondent defendant in the case. But Deputy Attorney General Ramsay, representing the Attorney General's office, indicated that that cannot be the case because the Chief Justice can only use a separate lawyer in the case if constitutionally they have opposing sides. But because they have the same view, it is mandatory that the Attorney General represents the Chief Justice, since constitutionally the Attorney General is the one who represents all public or government officials in cases. Now, in ruling on that objection raised by Frank Davis, presiding judge Gibos Kopaman indicated that he's going to overrule that objection by Frank Davis, adding that the Chief already sent a representative who's in the judicial office to represent him, and his legal representative is the Attorney General, pending or in the event that there's any divergent views, the Attorney General is the one supposed to represent, but he gave his full reasoning in his decision on the motion itself. And then Frank Davis now went ahead to move the motion, the injunction, interlocutory injunction motion. He argued that the injunction is not granted, irreparable damage will be patient on person and essentially the applicants, in this case, Kojo Nkrumah. Now, his sole argument, or one of his arguments, was that the practice direction over the years is that lawyers in the matters tend to agree with the presiding judge on cases when they should be heard during the legal vacation. And so it cannot be that the Chief Justice will give a direction mandatorily for legal vacation judges or vacation courts to sit during the legal vacation.
Very well. Let's take a listen. Let's take a listen to lawyer for Kojo Ponkroma, Frank Davis, on this matter.
A minimum of 300,000.